And the next part is the analysis of legal problems of this Moot problem. So first, the issue is the prerequisite is determining the applicable standard condition which govern this dispute, since this will decide the other issues, which is also really important. So the first one is they will decide to what extent the claimant is obligated, and the second one is whether he fulfilled the duty, and most importantly, whether he is entitled to the 1.2 million and 2.5 million in damages and no need to bear the cost of this arbitration. So let's go to the terms of the agreement. So first, the claimant's general condition govern the agreement, and claimant did not breach it because they have used best efforts to satisfy the obligations. So first, the invitation of tender from the respondent is purely an invitation for offers, since the respondent disseminated the invitation of tender to 5 business and even publicized in the industrial newsletter, which it's everyone in the industrial, everyone, maybe the outside the industrial will know the invitation to tender. So therefore, the respondent's tender document were not an offer because it's not a specific person according to Article 14 of CISG. And so the claimant's letter of acknowledgement was not an acceptance to an offer. So going on is the claimant's sales offer, which is satisfy Article 14 of CISG, because it states first, addressing to a specific person, which is the respondent, and second, it indicates the intention to be bound by the acceptance. And the last one is the goods and fix of the quality and the price are also indicated in the sales offer. So the goods are the cakes, and the fix of quantity is the 20,000 per days of the cake, unless the price is $2 USD. So let's go on to the respondent who welcomed a claimant's sales offer and accepted without objection or modification, just by replying that it's a decision. The decisive element in this decision is to accept claimant's sales offer was because of claimant's impressive codes of conduct. And then it says anything but without further negotiation about the agreement. So it's welcoming the claimant's sales offer. And even if the tribunal finds respondent's tender documents were an offer and claimant's letter of acknowledgement was an acceptance, which is pursuant to Article 19 of CISG, it states that apply to an offer which proposed to be an acceptance. If the tribunal finds it, the claimant's general condition still apply because of acting as an effective modification, which is pursuant to Article 19, it states that condense additional or different terms which do not materially alter the terms of the offer constitute an acceptance, and the terms of the contract are the terms of the offer with the modification content in the concept, in the acceptance. So it's of the existing agreement between the two parties. So this effective modification, that is the general condition in the claimant's sales offer, is still applicable. And in view of the fact that the general condition cover the change the product type and the price term, the applicable codes of conduct previously from the respondent shall be replaced by claimant's standard condition. And also, the sales offer from the claimant was enclosed to the claimant's standard condition, which is the last document to form this agreement. So, and going on that, by thoroughly read the claimant's code of conduct as a whole, we will know that the claimant was only required to provide its best efforts concerning the supplier's compliance. Like include first one, the suppliers are expected to maintain and to be able to provide a claimant with documentation which demonstrate compliance to this supplier code of conduct. And then the second one is they said, we regularly monitor our suppliers and ask about their business practice. And the third one is, we reserve the right to audit compliance to these guidelines. So the claimant has just say that they will use their best effort to ensure the suppliers comply with the code of conduct, but you never say that it's a 100%, I will guarantee it happen. So then let's move on. How the claimant has used its best effort. By using best effort, the claimant has a monitor and require third-party accreditation to its suppliers, and then investigated the scandal and even provide a remedy after the scandal. So the claimant has complied with the agreement. And even in the unlikely event that the respondent's general conditions are applicable, I still think that the claimant remains only obligated to use its best effort while assuring compliance by its supplier. So if this tribunal finds the respondent's general conditions are applicable, it still merely requires the claimant to utilize its best efforts. By interpreting the respondent's general condition in accordance with the Article 8, Subtitle 1 of CISG, which says that for the purpose of this convention, statements made by or and other conduct of a party are to be interpreted according to his intent. So intent is really important, and that's the way how we interpret the agreement. So the intent for including such provision in the condition, that is first, attacking necessary corrective actions in a timely manner, which is in the page 31 of the fact. They say they will tackle non-compliance by its supplier, so it's never an absolute guarantee of compliance, but simply requires using its best effort to ensure the compliance. And also, it manifests that respondent would like the claimant to remedy the non-compliance of the supplier by corrective actions, but will not translate non-compliance of the supplier into the breach of the agreement from the claimant. So the last one is, the claimant has used its best effort to deliver cakes. In accordance with the respondent's code of conduct, the claimant has employed its best effort by the two actions. Well, the first one is requiring the people cocoa to sign the code of conduct for the suppliers, and there will be a review annually. And the second one is the claimant has contracted with the third-party experts, which is Egypt's AG, to inspect and scrutinize people's cocoa. So they are make so many efforts, the best effort to ensure the compliance and deliver the cakes. So conclusion about the analysis of this legal problem, the claimant is entitled to the 1.2 million and at least 2.5 million in damages, and also the respondent should bear the cost of this arbitration. That will be my conclusion. And this analysis happens to be in favor of the claimants, but there are adequate facts in the problems that can be argued for the respondent as well. So I conclude my submission here. Thank you a lot.